Hello. Today's topic, today's lecture is dedicated to contracts. Днешната лекция, днешният урок е посветен на договор. What is a contract? A contract is an agreement to do or not to do something. A contract is an agreement between two or more competent parties based upon legal subject matter and sufficient consideration to do or not to do a particular thing. Contracts are either written or oral. Договор. Писмен, устен. Important contracts are in a written form. For example, a contract for sale of land will always be in a written form. Oral. An oral contract is an agreement upon which two competent parties agree in an oral form. Договор. Писмен и устен. Executed contract. What is an executed contract? An executed contract means изпълнен договор. For example, an executed contract is a contract in which nothing remains to be done. Everything is done. A person who buys a newspaper in the streets receives the newspaper and the vendor receives the money. So this is an example for an executed contract. Executory contract. Executory contract means недовършен, незавършен договор. An executory contract is one in which something remains to be completed. For example, an agreement to build a school for a town. Implied contract. Implied contract is a very tricky term. Implied contract means предполагаем, подразбиращ се договор. What is an implied contract all about? An implied contract is one inferred by the law from acts, conduct, and circumstances surrounding the transaction. The implied contract is not created or evidenced by an explicit agreement of the parties. Express contract. Express contract means очевиден, явен договор. An express contract is an oral or written agreement of the parties that has clearly stated terms in express and distinct language at the time of making. An express contract is one in which the terms are clearly stated in words. В един явен, ясен договор условията са точно дефинирани с думи. Now we come to another term which is very complicated. Consideration. Consideration, in plain English, means соображение. But consideration in legal English means prestatia. So consideration is a legal term here written. The thing of value in exchange for which a promise is given in a contract is called the consideration. To be binding, a contract must be based upon legal consideration. Next term, offer. What is an offer? An offer is a noun, and it is a proposal by a person to contract with another person. An offer, which is a requirement of a valid contract, is a proposal to make a contract. The word offer is also used as a verb, meaning to present for acceptance or rejection something. Next term, acceptance. Offer – предложение, acceptance – приемане. An unqualified agreement to the proposal of another is acceptance. Acceptance is an essential of every valid contract element. Acceptance may be either express or implied from circumstances surrounding a transaction. Infant. Who is an infant? This word is derived from the Latin word in and fan. An infant cannot speak legally for himself or herself. A person of either sex who is under full legal age is an infant. An infant may contract for necessities if there are which are not provided by a parent. Непълнолетен или малолетен човек. Minor. A minor is a person who has not reached the age at which the law recognizes contractual capacity, called majority. A synonym for the word infant is minor. So both terms, infant and minor, are synonyms. Също означава непълнолетен или малолетен човек. Breach. Breach, in the wide sense of the word, means нарушение. Breach is derived from the ancient Anglo-Saxon word brecon. A breach is the breaking or violating of a law, right, or duty, either by doing or failing to do something. What is a breach of contract? A person who fails to perform promises made in a contract with another is guilty of breach of contract. Breach of contract. нарушение на договор. Нарушение на договор. Fraud. What is the meaning of fraud? Измама. В юридическия смисъл на дума. Fraud means deceit, cheating, or trickery. Fraud is intentional deception to cause a person to give up property or some lawful rights. Fraud is a broad term describing all kinds of acts that aim to take advantage of another to his or her detriment by deceitful means. To the detriment of means в ущърб на, във вреда на. Undue influence. Undue means unlawful, незаконен. Undue influence means злоупотреба с власт. When an individual uses improper persuasion on another, that results in that person's acting against his or her interest in a way he or she would not have with a free will, undue influence has been exerted. So it is very typical, exerted undue influence. Упражняване, осъществяване, злоупотреба с власт. Undue influence is sometimes exercised upon an elderly or ill persons who are making a will by relatives, housekeepers, or lawyers to gain their own advantage. So, bail. What is a bail? Залог, гаранция, поръчителство. Bailment, a very typical legal term. Даване имущество за съхранение, под съхранение, с една или друга цел. Delivery of personal property in trust is called a bailment. In a bailment, a person's property is delivered to another for the purpose of keeping it safe. A bailment is a transfer of possession only. Bailer. Who is a bailer? A person who stores furniture in a warehouse for safekeeping purposes with the intention of retrieving it within a stated time that is paid for is a bailer. Човек, даващ имущество за съхранение. Свое собствено имущество, дадено на друго лице за съхранение, с една или друга цел. Бейли. Who is a bailey? Лицето, на което се дава имущество за съхранение. A bailey is one who receives personal property of another for safekeeping. A bailey holds personal property of another in trust for a specific purpose. A pawnbroker is a bailey. What is a pawnbroker? Съдържател на заложна къща. Съдържателите на заложна къща са бейли. Също. Хора, на които е дадено да съхраняват вещи на други лица. Собственост на други лица. Now we come to really important more terms. Competent parties. To make a contract, parties should be competent. Both parties should be competent. An essential of a binding legal contract is that it be made by competent parties. Competent parties are legally qualified people who are capable of contracting. Това значи хора, които разбират смисъла и значението на това, което вършат и могат да сключват договори. Incompetent. Incompetent is an antonym of competent. Incompetent. One who is incompetent is without adequate ability, knowledge, or fitness to perform. A person may be incompetent by law to contract because of mental deficiency, for example. Novation. Новация. Също означава заменяне на старо задължение с ново. The substitution of a new contract between the same or different parties is also called a novation. The substitution of a new debt for another is a novation. Option. Опция се превежда и на български. Избор означава и право на закупуване. An option is an offer in which is added a certain amount of time for consideration. An option is a contract in which one person pays money for the right to buy something from or sell something to another person at a certain price and within a certain time period. Sometimes an option is given in terms of a choice of buying or not buying something. Опция. Default означава две неща. Неизпълнение на задължение и неустойка. Среща се и в двата смисъла. Default in legal procedure is a failure of a party to a lawsuit to take a step or perform an act required by law. Default is an omission to do what should be done. Omission е пропуск. Default. Неизпълнение на задължение означава пропуск да се извърши нещо предписано от закона. Should the defendant not make answer to a plaintiff's complaint in a case, judgment by default will be taken against the defendant. Landlord. Landlord. Собственик на земя. Но тази дума се използва като термин не само за собственик на земя, но собственик на мотел, хотел, къща за гости и други недвижими вещи от голямо значение. A person who owns and controls property rented or leased to another is a landlord. A landlord is the owner of leased property. The person from whom lands or buildings are rented is called a landlord. A person who keeps a rooming house, inn, hotel, or motel is also a landlord. Tenant, наемател. Who is a tenant? A person who occupies property with the consent of a landlord is a tenant. A tenant has temporary possession of property. A tenant occupies property subject to the rights of the landlord. A person who rents or leases property from a landlord is a tenant. Lease. What is a lease? Договор за наем. The contract definitely establishing a relationship between a landlord and a tenant is a lease. Тоест, договор между собственик и ползвател-наемател е лиз, договор за наем. A lease is an agreement that grants to a tenant the right to occupy a certain property owned by a landlord for the stated period of time in return for a stated rental and meeting some other conditions. Any written agreement that gives rise to a landlord-tenant relationship is a lease. Всеки договор, който създава взаимоотношения между собственик и ползващ даден имот наемател, се нарича lease. Who is a leaser? One who gives a lease is a leaser. Наемодател. A landlord who grants a lease is called a leaser. A leaser usually receives consideration in the form of rents or in other forms. Тук отново употребяваме думата consideration в смисъл на престация, юридическия термин на престация, който въведех в началото. Lessee. Who is a lessee? Наемател. Отново. A tenant who is given possession of land under a lease is called a lessee. The lessee is the person to whom a lease is made. The terms lessee and tenant are practically synonymous.